Thank you, first of all, for inviting the Ombudsman staff to speak with you. We consider this area to be a priority area for the Ombudsman. I'm going to divide my speech up into three sections: what, why, and how. The what is, okay, what is the Ombudsman, what does he do? Why do we do it? Why is it important? And how do we do it? And in speaking about, on the third section, I'll focus principally on transparency and on access to documents, which is one of the primary areas of transparency. As was already mentioned by Deborah, the European Ombudsman carries out inquiries when there are complaints concerning maladministration by European institutions, bodies, offices, and agencies. He has wide powers of inquiries. Institutions and agencies, I'll just use that as a short term, rather than institutions, bodies, offices, and agencies, are required to respond to the inquiries of the Ombudsman. He also can carry out inspections of the files of the institutions and agencies. This is obviously very important in access to documents cases, because one of the problems in access to documents cases is the person looking for the documents doesn't see them and therefore can't verify whether the arguments put forward by the institution or agency are actually correspond to the facts. So we can actually go and look at the documents in situ, which we have done, for example, with the European Medicines Agency cases, in order to verify whether or not those arguments are justified. Why do we have a European Ombudsman? The European Ombudsman was introduced with the Treaty of Maastricht, along with a whole series of provisions concerning the creation of European citizenship. And that's a very important observation, because before the Treaty of Maastricht, what was then the European Community, didn't really have any concerns about interacting with citizens. The interlocutors were member states, and citizens were simply forgotten. Since the Treaty of Maastricht, it has become important to engage with citizens in order to deal with what is broadly referred to as the democratic deficit in the EU. In order to do that, we must build trust in the EU institutions and agencies, and thereby trust in the EU. In order to do that, we need to ensure that citizens know exactly what the institutions and agencies are doing, and access to documents is an incredibly important part of that process. And that is why the European Ombudsman puts enormous emphasis on issues relating to transparency. When we carry out an inquiry, we can make proposals for friendly solutions to the institutions and agencies with a view to putting problems that have been identified right. We can also make draft recommendations, which we tell them what they should do in order to put things right. And eventually, we can make a special report to Parliament, the European Parliament, if we consider the issue to be extremely important. It's important to note that the Ombudsman's proposals for friendly solutions, draft recommendations, special reports, and eventually his findings, which are set out in decisions, are not binding. Unlike the courts, where the courts can annul decisions of the institutions and agencies, the Ombudsman can only make non-binding recommendations and decisions. Basically, he relies on his moral authority in order to try and convince the institutions and agencies to change their behaviour when that behaviour has been identified as being inappropriate. While the Ombudsman can only issue non-binding rulings, the facts show that in the vast majority of cases, those findings are followed. And we're happy to say, as regards we have Dr. Eicher from the European Medicines Agency. I think the European Medicines Agency is a prime example of an agency that has changed to a great extent its modus operandi in relation to access to documents as a result of inquiries made by the Ombudsman. I referred to transparency and access to documents. Access to documents is part of a wider transparency agenda. Some of those other issues were already mentioned this afternoon, such as, for example, issues of conflicts of interest. We've quite a number of cases in that area, issues of revolving doors. So individuals who have worked for industry and go into an agency, or work for an agency and go into industry. However, access to documents is the biggest issue which we face in the area of transparency. The cases that we've dealt with in relation to the European Medicines Agency, the first major case related to, was mentioned by Deborah, the Roaccutane case. The Roaccutane case, the complainant was a gentleman whose son had committed suicide subsequent to taking a course of Roaccutane, which is, if you're unaware, it's a medication produced by Roche for treating severe forms of acne. One of the contraindications, which is accepted exists for Roaccutane, is that it causes depression and suicidal thoughts in the persons who take it. And medical practitioners are required now to be aware of that particular contraindication and to monitor it. The father of the young man who died wanted to obtain from the European Medicines Agency the adverse drug reaction reports that were held by the European Medicines Agency concerning Roaccutane. And there was a major difference of opinion at that time between the Ombudsman and the Medicines Agency, because the Medicines Agency first of all argued that the general access to document rules at EU level did not apply to the Medicines Agency. They also raised issues as regards the commercial sensitivity of the documents, although that argument was dropped very quickly. Happily, subsequent to draft recommendation by the Ombudsman, the European Medicines Agency first of all agreed that the access to document rules did apply, and that in this particular case, subsequent to removing the personal data, which was the personal data of the patients and also of the treating doctors, that the adverse drug reaction reports would be provided to this gentleman. While it was, of course, very important for the person concerned to obtain access to these particular adverse drug reaction reports, by the way, he wanted them in order so as to proceed with an action for damages against Roche before the Irish courts. While it was very important for him, it also marked a sea change in the general attitude of the European Medicines Agency to access to document rules. And we saw this also in the case submitted by the Cochrane Institute, which related to access to clinical trials data concerning anti-obesity drugs, that they have taken a far more appropriate position as regards access to documents held by the European Medicines Agency. When we talk about requests for access to documents, of course what we're talking about is reactive transparency. You have to ask for it, and if an exception doesn't apply, you should be given access. The Ombudsman has also put emphasis on the importance of proactive transparency. That means making available in the normal course of business the information in the possession of the agency, which would imply that those that are interested in the information don't have to go to the sometimes burdensome task of requesting it and waiting for it. Another one of the points made by the Ombudsman in relation to this proactive transparency agenda is that efforts should be made in order to make the information that is held by the agency as understandable as possible. Now, of course, there are limits to this. Reasonable efforts should be made. Of course, this is sometimes extremely technical data. However, the manner in which information is stored by the agency, it should be considered, in addition to the other practical issues that arise as regards the use of the data by the Medicines Agency, thought should be given also to the needs of civil society who may wish to obtain access to that information. So, for example, how information is stored in the Vigilance database. It should be considered when those systems are being organised. It should be considered how that information can be best made accessible to the public. One of the points that has been raised in the various discussions this afternoon relates to the fact that there is data which is not reported to the European Medicines Agency or to other national regulatory authorities. It's important to note that the European Ombudsman's mandate only relates to the activities of European institutions and agencies. That means that we can only deal with complaints in relation to the non-disclosure of documents that they hold. So if a pharmaceutical company doesn't submit to the European Medicines Agency relevant data, that's something that falls outside of our mandate. So again, I think it's an important point to make, because I think it's an important issue to discuss, but it relates more to what is the regulatory framework which obliges pharmaceutical companies, the powers that EMA has to require that information. Potentially there would be an issue if an argument were made that the European Medicines Agency was not correctly exercising its powers and omitting to gather information that it has a right to gather, but no such complaint has been made to us. I'm unaware whether that a problem arises. But as regards access to documents, what we can do is look at complaints in relation to documents that are held by the agency. The EU access to document rules operate on the presumption that every document held by an institution or agency must be made public unless the institution or agency puts forward an exception which would justify non-disclosure. That's a very important point. One of the problems that arose in the Rockutane case initially, in the context with the gentleman who wished to obtain access, was that he was being asked to demonstrate why he wanted it. There is no obligation under the EU access to document rules to justify why you want something. The obligation, in contrast, is on the agency to justify why access should not be given. And those exceptions are limited. I mentioned one already concerning the protection of privacy and personal data, and that's not a controversial issue. There's no doubt that the names of patients, even the names of treating doctors, should not be disclosed. The only problem that arises in that area is organising your data so that you can easily remove references to patients and treating doctors before releasing it. So again, comes back down to the point I was making about when you design your IT systems, you should do so taking into account the possible future need to release the documents, which should mean that you should design it in such a way that you can easily remove that personal data in order to allow quick release to the public. The more controversial issues which relate to the exceptions to public access relate to the need to protect the capacity of the agency to carry out its investigations, which is a time-related issue. If the agency obtains information and is in the process of analysing it, the question would arise whether or not release at that point in time might put undue pressure on that particular investigation. But the obligation would again be on the agency to show specifically that the release of the information at that point in time would actually undermine their capacity to carry out the investigation. And finally, and probably most controversially, there is the issue of the protection of commercial interests. This is something I understand that many pharmaceutical companies, when they submit information to the regulatory authority, automatically categorize their information as constituting that disclosure of that information would damage their commercial interests. It's important to point out that the EU case law distinguishes between what is a legitimate commercial interest and what is not a legitimate commercial interest. It is not a legitimate commercial interest to wish to not disclose data which would damage sales simply because the data would indicate that a drug doesn't work. I say this, for example, there are cases in other areas of EU law which apply exactly the same rules, which relate to infringements of competition law. What the European courts have stated is that the fact that your commercial interests might be damaged by the release of information which would indicate that in an antitrust competition law investigation that a company had infringed the competition rules, that might damage your commercial interest, but it's not a legitimate commercial interest. If you were to apply that principle by analogy to the area of the European Medicines Agency, it would imply that the release of data concerning, let's say, an ineffective clinical trial might damage commercial interest, but it's not a legitimate commercial interest. A legitimate commercial interest which would be worthy of protection by the non-disclosure of that data would have to be something that would damage your competitive position on the market by, for example, providing your competitors with access to data which would allow them to produce competing products, for example. So, again, I'm a lawyer, I'm not a scientist or a doctor. It's up to you, if you were looking at a particular set of data, to determine whether or not such data would be of commercial benefit to competitors. But that's the type of analysis that should be done. And then the important point, and I'll finish on this, it's for the person who argues that the information is commercially sensitive to prove it. So it's for the agency, when it justifies non-disclosure, to say why the information is commercially sensitive. And if needs be, what they should do is contact the pharmaceutical company and say, you're putting forward this argument, you should demonstrate that that argument is actually factually true. And the other point to make, and I'll finish on this one sentence, is that all data which may be commercially sensitive is normally only commercially sensitive for a certain period of time. And when a request for access is made, let's say we're referring here to data, you're referring to data which is up to 10, 15 years old. Whenever a request for public access is made, a new analysis should be made as regards whether or not the information, which might at one point in time have been commercially sensitive, a new analysis should be carried out in order to determine whether that exception is still valid.